got a half hour.
I've already started the timer, sir.
So the broader realization I'm having as I'm hearing these defense arguments, Your Honor, is that this Baker case came out, and it's a case that applies 403, but it doesn't change the law on 403. I think we're getting arguments that sound similar to the idea that, you know, Baker came out and there's this case where a rap video was excluded, so therefore that's now a change in the law that means all rap type evidence is now radioactive under 403. That's a flawed proposition, as I'm going to get into. So I'm going to start with Mr. Williams' arguments, and then I'm going to try to get into Mr. Stillwell's arguments in a little bit more specific. And I may refer to my colleagues when it comes to the granularity, but I just wanted to provide an outline of our thoughts on the law here. So Baker, it's being touted as though it kind of automatically operates to vacate this court's lyrics order from November. That's not the case. It doesn't suggest that. It certainly doesn't compel that. I want to start with the fact that Baker is a 403 case. And as such, it's a limited fact-specific holding. We know that the court and all the parties have read Baker, but just to reiterate, the sole enumeration of error in Baker was the trial court abused 403 in letting this video in, okay? So there was a pretrial motion in limine to exclude specifically this video, by the way, a particularized pretrial motion. And then the trial court's order denying that motion said, oh yeah, it's relevant for identity, and it's relevant to show his relationship to this other guy, who's unindicted third party, by the way. So with really no explanation, the trial court just said, yeah, it passes 403. And then there you have it, it gets in. Notably, as pointed out by my colleagues, Baker's identity at the nightclub where the incident happened was absolutely uncontested at trial. Further, Baker's relationship with his tour manager, which he had known since childhood, was also totally undisputed, and it wasn't even a material issue in this single defendant murder trial. Okay, that's a big difference between the charging posture of that case and the case here. So given all that, it's pretty easy to see how the Supreme Court said, yeah, it doesn't really have any probative value. It's a murder case, and they're throwing in this rap video that was filmed, I don't know, several months before that's got nothing to do with the murder. Highly, wildly distinguishable from the facts in our case. So the video, like, there's nothing really in the video connecting the guy to the murder. But meanwhile, what it does show, and what my colleagues have pointed out, was that it does show Baker dancing and brandishing a semi-automatic pistol with apparently an extended magazine, and he's pointing it at the camera, at the jurors, when they watch the video. And they watched it 3 times, okay? The prosecution, our colleagues over in Houston County, they made hay with this video, okay? They played it 3 times. They played it once during the lead detective's direct. The suggestion was that, you know, this is a violent gunman. They played it again during cross-examination when Baker took the stand to kind of confront the idea like, oh, well, why would I have guns around? No, this is why, because look at this video. You're a violent gunman. So they're reinforcing this propensity argument in Baker, and then they really nail it to the wall in closing in Baker, where they just drive it home that not only is Baker have this propensity to commit gun violence, but he has this propensity to promote it and glorify it in this video. And it became a central focus of the case. I mean, that's right at page 32 in Baker. It was proof essentially of nothing, Your Honor, and it became a central focus of the case in Baker. And so when you talk about, the idea that 403 contemplates that you can look at a piece of evidence and kind of look at its tendency to lure the fact finder into declaring guilt on an improper basis, it's absolutely, I mean, the Supreme Court had to conclude what it did about the video on Baker.
Because of their use of the video.
Exactly, and because of the fact that it had really it proved nothing that was at issue. So it had 0 probative value, and it had whatever prejudice was inherent in the imagery, it multiplied it by 3, and they made absolute hay of it in closing and throughout cross and during direct. And I also want to point out another very important difference. Well, I'll get to that later. I guess I want to just say, look, this case, Baker, it doesn't change 403. It's an example, the court should consider it. And really, the court's lyrics order leaves open at trial objections under 403. So Baker leaves the court's lyrics order undisturbed. That's the headline here. The court's lyrics order is kind of like it's is pretty robust. It was pretty assiduously researched, and it accounted for stuff like this. And it left open, as Your Honor is aware, foundation and 403 objections and further findings possibly at trial if and when such evidence is going to be admitted. So to go ahead and say it undoes the whole lyrics order or any part of it, that is not correct. Everybody has their 403 objections. To say that Baker automatically excludes any and all of the state's requested evidence under the lyrics order, it's too much. I want to remind this court that, as everyone knows, 403 is an extraordinary remedy to be used only sparingly, okay? This is not a blanket thing that we're going to use to exclude all categories of evidence that fall under, rap videos, right? And then also I thought, which was interesting, is a Georgia Court of Appeals decision that came out March 14 of this year. It's going to be Anderson v. State, and the Lexis site is going to be 2024 Georgia Appellate Lexis 127, and that's at 8, and it's footnote 3, and it says something that I hadn't actually seen it put this way, but it says the prejudice referred to in Rule 403 addresses prejudice to the integrity of the trial process, not prejudice to a particular party or witness. The reason they want to keep all this stuff out is, it's prejudicial, but they're arguing that it's not relevant. They wouldn't be arguing to keep it out if it weren't relevant. It is relevant. Under 401 and 402, we're already there. So for that reason, I think the limited nature of Baker as a 403 holding, Your Honor, follow the law to the extent that these, my colleagues' motions are consider Baker. We agree, consider Baker, right? But don't vacate your order and don't alter the order. It stays the same. Now, Baker, as Your Honor is also aware, is highly distinguishable. Again, there was a pretrial particularized motion to exclude a specific video called Ghetto Angels under 403, whereas to date, at least from Mr. Williams, we have no particularized challenge to any of the lyrics that were previously admitted by way of this court's order. We have sweeping pronouncements about criminalizing art, generic invocations of 403, 404, but really there's no specific lyric that Williams has pointed to that is attributable to him that he finds objectionable, or at least he hasn't made any argument as to any specific lyrics why they should be excluded under Rule 403. I didn't hear one. I didn't see one in the motion. I didn't hear one argued before Your Honor today. And highly important in Baker, the video had some disturbing imagery, etc., but the lyrics were explicitly not at issue. It's not a lyrics decision, Your Honor. It's a 403 decision on imagery. It literally says on page 18, footnote 13, the lyrics have no bearing on our conclusion that the rap music video was improperly admitted. That is highly important. I didn't hear any defense address that, because in this case, the lyrics as statements, by the way, they're not just songs, they're statements, and they're statements by parties in this case. But the lyrics are exactly what was issued, and Your Honor already correctly ruled on the same, okay? We ruled on them as admissions of a party opponent under 801 D2A. John Floyd came down here, Mike Carlson came down here, Deputy District Attorney Hilton. We put on a heck of a proffer. It went for hours, okay? We put them in as adoptive admissions under 801 D2B. They came in under co-conspirator admissions under 801 D2E, statements against interests under 804B3. And in Baker, they're not talking about 801 at all because the words, the statements, the lyrics were indecipherable. They were not reached. The court made no pronouncement on the prejudicial, if any, effect of the lyrics because they just weren't heard. So it's not a lyrics decision. That's extremely important. And admissions, and this goes to Mr. Shart's arguments as well, but when you have party admissions, and we're talking about like a video where we have Stillwell saying the words. You can see him saying these words. I just beat a murder rap. I paid my lawyer $30 for that. Me and my signs above the law. And we're told that that has no relevance to a charged count in this indictment and to overt acts under the RICO count 1 of this indictment. It's a little bit of to me, it's a stretch. But the fact that the Supreme Court in Baker didn't consider the lyrics at all, let alone analyze them under 801, makes this case in a different universe than the lyrics we have here, because it's just not talking about statements. It's not a statements case. And then lastly, a big difference that I noticed in Baker is that it's, again, it's a single defendant murder trial, whereas here we got a multi-defendant RICO and Gang Act prosecution. Williams' motion says, oh, it's no difference that he's charged under RICO and Gang Act. It makes all the difference in the world. All other things being equal, in a single defendant murder trial, it's not necessary or material for the prosecution to show relationships or associations, like they tried to in Baker with the guy's tour manager, like that made any difference. And it certainly wasn't required even under the facts of Baker because his association was totally undisputed. So again, the probative value was nothing there. Here, by contrast, which is consistent with this court's lyrics order, the relationship between and among these co-defendants, as well as their association with the alleged YSL street gang and criminal enterprise, those are crucial. In specific, because the defendants categorically have denied that YSL is either of those things. They've denied that it's a street gang. They've denied that it's a criminal enterprise. So the prosecutorial need to show that is absolutely not minimal or low, as argued by my colleagues. It's extremely crucial in this case in light of those denials. So the lyrics evidence in this case, already properly admitted, relates to, just as a reminder, the nature and existence of the alleged criminal enterprise / gang, the affiliations with the alleged criminal enterprise and gang, participation in the alleged criminal enterprise and gang association and membership, participation, and the connection of the defendants with one another. You can look at your order. It's at page 19, 24, 26, and 37 through 42. Those were already all found to be permissible purposes for the lyrics evidence in this case. So for that reason, Williams' motion should not be granted. And I want to talk about intrinsic evidence, okay? Baker does talk about intrinsic evidence, but that's of no consequence in this matter because in Baker, the only reason the Supreme Court was addressing intrinsic evidence was that the state on appeal came up with this argument, which was not made at trial, that, oh yeah, the video is intrinsic because, and if you look at the oral arguments in Baker, the basic argument is, well, Baker thinks he's a big shot and he can get away with murder and do stuff like this. That was the intrinsic argument that was made in Baker. So again, it's not hard to see why the Supreme Court rejected that argument. And again, at best, as intrinsic evidence, quote unquote, adding to the story of the crime that happened in one night, a murder that happened in one night, adding to that a video that was filmed several months before and saying that's intrinsic and essential to telling of the story of the crime. Again, the Supreme Court had to conclude that the intrinsic arguments didn't work. And the only reason they addressed them is because the state kind of threw them up as a Hail Mary on appeal. Again, the video provided basically needless corroboration of tangents related to the story of crime. And there was already extensive, definitive, and undisputed evidence at trial of all these tangents. So it's not surprising to see the Supreme Court do what it did here. But again, that rejection, it doesn't affect the state's position in this case or the court's previous ruling on the lyrics evidence when it comes to intrinsic evidence. You look at intrinsic evidence on a case-by-case basis. The law on intrinsic evidence is the same today as it was in November of last year when this court entered its order, which appropriately considered the law on intrinsic evidence. And there's a Third Circuit Court of Appeals a quote that I've found here that I would like to bring to the court's attention, which just has to do with some of the direct evidence. You know, we talked about intrinsic, we talked about admissions, we talked about proving association, membership, et cetera, stuff like that. But then there's also direct evidence, right? And that's nowhere more obvious than when you look at the lyrics that Stillwell is trying to exclude about beating a murder rap and he's above the law and him and his slimes and YSL for life and all this other stuff. It's like, how are you saying that's not direct evidence of what we're trying to prove here? It kind of it seems like it defies logic. But the Third Circuit Court of Appeals in United States v. Johnson, and this is a February 14, 2024 decision, found at 2024 U.S. Appellate Lexus 3436 at page 12. The Court of Appeals in the Third Circuit explained as follows. If someone tells you, quote, I have guns and drugs, and then you find guns and drugs in their house, this statement is direct proof that the guns and drugs are in fact his. That he says it in rhyme does not change that. How a jury chooses to weigh that evidence is another matter, okay? But the evidence is analytically intrinsic. The appellant here, Johnson, contends that rap is often hyperbolic or fictional art form. You know, while not all art is necessarily admissible as autobiography, the district court here acted within its discretion and leaving that question for the jury. And that dovetails, Your Honor, to a little bit of a larger point that I think I'm finding makes sense here, which is a lot of these arguments are very good closing arguments, but to make them now at this stage, it's very insulting to our jurors. I mean, we spent months selecting these jurors, and we screened them for these issues about, are you going to read these lyrics and automatically think they're autobiographical? We took a while to get a jury that both sides could agree on. And to say that, oh, they're going to be horrified, they're going to be inflamed, they're not going to know what to do, it's very insulting, especially when you consider the jury, Your Honor, as the constitutionally designated fact finder. And we're talking about arguments from the defense that we got to shield them from all this unsavory detail. They're the fact finder. The Constitution says so. The United States and the Georgia Constitution says so. 403 is a statutory rule, and it's to be applied sparingly. It doesn't override the jury's role as fact finder, in my opinion. The last thing I'll make on this, and I got some feedback here, I apologize, is that, as Your Honor is well aware, the lyrics evidence in this case is not propensity evidence. It hasn't been offered as such, and, I think Williams in his motion is kind of just conclusorily asserting that it's propensity, and I guess Mr. Shard is kind of piggybacking on that. There was a lot of discussion in Baker of how it's improper to use propensity evidence, but it's also worth noting that in Baker, the use of the evidence, there really was no arguable reason that they would want to include that disturbing imagery other than to, quote, cast emphatically Baker as a violent gunman. The jury's trying to figure out this murder that happens in one night and the split-second decision that somebody may or may not have made about a bullet that went through a security guard. And then it's like, well, what kind of person would do that, And it's like, well, how about this kind of person? The kind of person in this video. And it changed the whole dynamic of the case. This is in stark contrast to what we have here when it comes to the lyric evidence in this case, which this court has already correctly ruled on.
How would you address Mr. Shard's issue of, okay, you got about robbing drug dealers, carrying a stick, and the I beat a murder rap, paid my lawyer $30, etc.
Nature and existence of the organization.
Okay.
So moving forward, I wanted to address something that came up.
I'd argue. Well, what about the last? What about the last? His last statement, beating a murder rap.
Well, it's a question for the jury. I mean, on one hand, you can say I beat a murder rap, which means I was falsely accused of murder and I was vindicated in court and I had nothing to do with it. And the jury's free to believe that. But then when you couple it with how much you paid your lawyer, you're bragging about money, and then you're bragging above and beyond that. You're not saying me and my clients follow the law. Me and my clients are within the law. You're saying me and my clients are above the law, which goes to the mindset and intent. And so it all goes to count one and then some. So it's not propensity, and the court's already ruled that the lyrics evidence is not going to be offered for that. And if that answers your question, I'll jump forward here a little bit. I wanted to go to Old Chief just briefly.
Okay.
To imply, because there was some discussion about 404B and how that plays into the 403 analysis. Again, Baker was a very limited circumstance where it was no other argument to make other than this had to be used to show propensity to encourage the jury to convict. That's what happened there. But that's not that's not any new type of application of the 403 rule. Again, Baker doesn't change the law on 404B, doesn't change the law on intrinsic, and doesn't change the law on 403 in general. The idea that, 403 encompasses evidence that may lure the fact finder into declaring guilt on an improper basis. Even in Old Chief back in 97, they said that such improper bases are to include bad character and propensity. So it's been the law for, some 20 years plus, at least, that propensity analysis does occur within a 403 analysis, and that's nothing new. Again, that goes to my point, which is Baker doesn't change the law on 403. It's been that way before, and it's been that way after. So the court already correctly applied that law in its lyrics order, and for that reason, we want the motion to be denied. And then the very last point I'll make with respect to Williams is that he's apparently trying to resurrect these arguments that failed before about how, because we don't know the provenance of these lyrics or these statements, or the meaning could be arguable, that's some sort of grounds for excluding them. But even in Baker, and the footnote that the defense is making hay about, footnote 16, even in footnote 16, it literally says that or acknowledges that those considerations go to probative value, not admissibility. They're talking about marginal probative utility and how, the failure of the state at trial to show that these people actually said this stuff versus it being kind of, put on them. That goes to weight, but weight is a jury question. The jury resolves the weight. Like, they can decide whether they think this means something or other, or whether they think, the fact that Stillwell's up there on the video saying the exact statement, are we supposed to attribute it to him, or do we attribute it to someone else for some reason? The jury is fully able and authorized to make those conclusions. So that's going to be my main sort of, one other thing. Baker, the fact that it's so wildly different from this case actually supports the state's position here, if you think about it, because there are so many differences as I outlined. And again, it's an extraordinary remedy that was applied in an extraordinary case. It was called for in Baker. It's not called for here. Just to reiterate, the very fact that the defense's opening statements, their cross-examination, and throughout this case have been categorically to deny that YSL is any kind of criminal enterprise, any kind of criminal street gang, any kind of anything other than a rap label, that elevates the prosecutorial need and the probativity of these pieces of lyrics evidence. And for those reasons, we think that the motion should be denied. Now, when it comes to Mr. Shart's arguments, those were more recently filed, so I don't have as developed of a take on them, and I may refer to co-counsel for some of these details. But the Smile It Off video, let's call that what? Was that Stillwell 1?
Yes.
I think we kind of already covered that with the, hey, my lawyer 30 to beat the murder rap, me and my science above the law. I mean, that's him talking. Like, there's no question about him being the person that said that. And more than that, you look at
being offered for any other reason other than identity, and are you talking about identity for what reason? Well, involvement in the criminal street gang, or identity in terms of the homicide?
Well, it could be for all those, but
I'm asking you because Mr. Shard has said, it's not really relevant, but he won't kind of concede that. But so tell us, or tell the court why it is it, or address those three issues. One of them is he's robbing drug dealers, okay? I mean, and he carries a stick. The last thing is I beat a murder rap for 30. I beat a murder rap, paid my lawyer 30, and then me and my slimes are above the law.
Well, I mean, that's overt Act 95. And so if you look at the indictment, overt Act 95 literally says that statement is in furtherance of the conspiracy. And if we can't play a video of him saying those words, how else can the state prove that act?
Okay, what about the robbing drug dealers and carrying a stick? Should I exclude that?
No.
Why not?
Well, it provides evidence of the nature and existence of the organization. It's not.
That's why I asked him. That's why I asked Mr. Shark. Did the homicide occur as a result of robbing a drug dealer, or was it allegedly Mr. Stillwell carrying a stick, assault weapon?
Well, there had to be some sort of weapon for this murder to have occurred. I don't have any specific nexus about why the sort of words before the words that are admissible are specific to this, but we do have an entire overt act built around it, and the things that are said in context, right before, right after, sort of the YSL associations, especially even in the Stillwell 2, where you have YSL for life and you have blood love all the time. You have all these indicators of this is evidence of the organization.
I get all that, but the specifics of robbing drug dealers and this defendant is purportedly carrying a stick. What relevant? I mean, that could potentially. Though, I want to parse out those three statements.
I'll take
I don't have any. Unlike Mr. Shart, the court doesn't have any. I disagree with him about the murder, about the statement about the murder rap. Okay, but I do think that you're going to need to address the issue of the robbing drug dealers and carrying a stick, unless you're going to, like I said, lay more foundation in regards to that.
Well, you're going to have we have allegations that Dirty Red is a drug dealer. We have Donovan Thomas, who was murdered with an assault rifle. and there's indications that it's a rival gang situation. So it's not maybe
the issue with Donald Thomas hasn't come up yet. At least I don't think so. The evidence hasn't been presented. But Dirty Red was just covered just a little while ago. So flesh that out for me in terms of robbing drug dealers or Dirty Red.
Well, they're talking about the stuff they do. I mean, talking about the way they do it. It's a party admission, Your Honor. These are parties making statements about the things that they do. It's highly probative. I mean, this is not somebody else saying something and it gets slapped on here. And there's, and they're not like in that Gamry case where you have a video where the defendant wasn't even present in the video. You have them. These are party admissions. Like what a defendant says, unless there's some specific statutory rule excluding it, like Miranda or something like that. These are extremely probative statements, and to just say, oh, the jury's going to be inflamed, we have to shield them from these facts, these things, these statements, these words that the defendants uttered for really, I don't know, no reason at all. To me, it just kind of strains credulity. And
I'm just making sure that under Gamory, that Gamory, that you got a video there that was minimally probative. I'm just asking you, as a proponent offering this figure evidence, if it's going to go to more, if what you're going to present will potentially be more probative than it has to be more probative than prejudicial, not minimally probative.
That's correct.
Okay.
And I take the court's point, which is that some of that stuff in Stilwell 1 is maybe more, at this point, obviously probative and direct than some of the other stuff, which may be at this point apparently more diffuse. But again, we have...
That's why I'm telling you at this point in time, I mean, all of it's subject to foundation, but, certainly it's something that I'm watching. I'm watching for the other stuff I've already admitted, but, or at least conditionally. And I think Mr. Shard is just raising this as part of his issue under what's been presented so far and under Baker.
Sure. And then I guess I'll just leave with one other piece of grain of sand here, which is the witness that we're kind of in the middle of, Miss A.B. The state's theory is, of course, that, she was robbed, she was dealing drugs, I mean, I can think of a lot of different things that the lyrics could apply to. There's no, with regard to those particular lyrics, I'm not able to pin down exactly one part of the case that applies to, but to say.
Well, that's what you have to. I mean, that's kind of what Baker and the other cases kind of tell me, is that I just can't admit this for shucks and giggles. I'm being over dramatic, but you have to admit it for tying to some specific or linkage from some particular nexus.
Well,
so that's why I'm telling you that that's why it's important.
I'll just default, Your Honor, back without wasting any more time. I'll default to the idea that it's an admission of a party concerning the nature of the enterprise.
Okay.
And how things work.
All right.
And with that, I guess, unless there are other questions, I'll conclude the presentation.
No, I'm good. All right. Thank you, sir.
Yes, sir.
All right, folks. I'm going to take probably about 10, 15 minutes. I need you to take comfort, and I would encourage y'all to do the same. And then I'll come back and let you know my thoughts, okay? All right, so we'll be in recess for about 15 minutes.